Good afternoon, Judge Vally. Please make yourself comfortable.
Thank you, Judge.
Are you well?
I'm well, Chief Justice.
Are you relaxed?
I'm relaxed. Thank you, Chief
Okay,
Justice.
thank you. Now, for how many years have you been a judge of the High Court?
I'm 6, I think. I think I'll finish 6 in less than a month's time
And where are you judging?
in the Gauteng High Court.
Where exactly?
I spend most of my time in the Johannesburg Local Division, but I do sit occasionally in the Gauteng Provincial Division, which is the Pretoria Division.
Have you had reasonable exposure serving in that division to competition law?
In so far as I had to deal with, I don't know if I had to unlawful competition cases, but those are more delictual. So yes, so I would say, but we don't get that many delictual unlawful competition cases. There's the odd one, yes.
Yes. Because after all, there is a specialized court in place to deal with
Competition law.
competition law.
Yes.
Okay. Now,
They're slightly different, though.
Yes.
Slightly different. I mean,
Yes.
there's, some may say substantially different, but
yes.
but there is an overlap, and I think when there's been a finding sometimes in the competition law, I think there was one such case, SA Airways, if I remember, but I might have forgotten, where there might have been a finding
Yes.
in the competition appeal court, and then there's a claim for
Yes.
damages,
Yes.
which is then brought out in the, I think there was the SA Airways case, but is there? There was Encom Air,
Yes.
both of which.
Now, if you add up your acting stints, for how long have you acted in the competition appeal court?
I think this is my second term. I'm not sure. It might be my second term. I know I got 2 letters of appointment.
Yes.
So that would be my second term, yeah.
Did you enjoy your stay there?
Yes, I did enjoy it. I would say so. It's slightly different from what I do in
Did you
the
find?
Gauteng High Court.
Oh, I'm sorry. Did you find it to be particularly complex or
I wouldn't
or
say
fairly?
no. That I have to say no. It's not.
It's not complex.
Not any more complex than what I deal with in the Gauteng divisions. I mean, there are far more complex cases I've dealt with.
Yes.
Far
Now-
more complex.
I got a sense, and I may be wrong, that cases that feature in that area of the law, where there is wrongdoing, so to speak, do not get visited with sanction that is sufficiently harsh to recognize the profoundly negative impact of unethical business conduct bordering on corruption on the public as well as it should. What is your sense?
There is that. There's a substantial amount of that. That's correct. And particularly when you deal with collusive practices
Yes.
and other such multifarious practices, yes, there's certainly a fair number of that. Whether they all come to the competition appeal court or not, I'm not sure, because
Sure.
sometimes they do settle them
Yes.
beforehand at the commission level and at the tribunal level.
If you look at the entire regulatory framework,
Yes.
it doesn't seem to be structured in such a way as to visit corrupt practice in the business environment with a harshness that we publicly cry out for when corruption is practiced or is committed in the public sector. And before I invite your comment, here lies my worry. If 2 legs are corrupt or cancerous, and you only deal with one leg, you have not addressed the problem.
Correct.
you are not sufficiently serious about uprooting that cancer or that problem. What then is it that should be done, if you agree with me, to make sure that we are harsh on corruption in the public sector, but equally harsh with corrupt practices in the private sector, rather than sugarcoat them?
I have great difficulty disagreeing with you, Chief Justice, because I mean, I agree with everything you've said. I think there has to be a firm stance taken on both, in both areas. And I do believe that there is some problems with regard to dealing with the kind of corrupt practices that they do take place in the private sector. I took note of that in one of the judgments I dealt with, which was Isipani, I think, where I felt they should get a harsh punishment. But I've taken note of that, and I believe the only way to stop it is to have this deterrence. To the extent that the criminal law might be able to be brought in, I think we need to look at it a bit more carefully. There is an attempt to do so. But I must say this, and it is the unfortunate part about our society, and that is that these practices are incredibly difficult to identify and to prove. And sometimes we just do not have the capacity to unveil them. I don't know, that's the impression I get.
Yes.
And so you do get a fair number of people getting away with practices they should not be getting away with it. In a sense, it's not very much different from those people who engage in nefarious practices like insider dealing on shares, etc. So there is that problem. It's there's so much secrecy and confidentiality involved in many of these things that it's hard to sometimes expose them and deal with them firmly.
I was raising it now at the level of saying, even those that are detected, there seems to be a number of possibilities of, having a softer way out. You can whistle blow, or even if you don't whistle blow, actually, once you are caught and exposed, you just tell on others, strike a deal that makes what you pay look like a joke. Shouldn't something be done about just the entire regulatory framework to make sure that it is sufficiently biting to discourage this kind of, at times, corrupt practice in the private sector?
I think as judges, we can only do what's possible within the confines of the law that's before us.
Yeah, I'm talking
and I
about...
do think the legislature might
yes.
have to, the legislature would then have to come in with regard to those issues. And it's the legislature who must give its guidance. Such as, for example, the legislature gave us guidance on minimum sentences. When the legislature said certain crimes are prevalent, then, and we have to do something about it. And the legislature is telling the courts, you need to take heed of what we are saying because we're acting in the public interest. And which is one of the factors to be taken into account when you look into punishing someone for having committed a misdeed. So it will have to be a thing that comes from the legislature. To the extent that what is available to us, I would agree with you, Chief Justice, that I think we mustn't at the same time pass the buck. I think there is something there for us, and we should show that when they have been exposed to us, we don't take kindly to them. On that score, Chief Justice, I concur wholeheartedly with what you have to say, that we have to show a firm stand, and we have to demonstrate a determination to end these corrupt practices.
Did your broader reflection on the legislation, regulations, give you a sense that the law in that area is complex because it's unavoidable, or it is complex in circumstances where it could be simplified to facilitate easy understanding by the practitioners in that area, including those charged with the responsibility to detect unacceptable conduct?
I think over the last 20 years that this law has been now allowed to mature, there has been a fair deal of clarity that has come out of it. I think there's a number of problems, not so much with the law only, but with the way things sometimes pan out in practice. I think the institutions might have to be more strengthened, their capacity. I don't know what it is, but they need to do some of those things. And I think there need to be an address also to some of the other issues that we have got over and above corruption, which I think is what the new amendment bill is trying to do. So there's a number of factors and interests that one has to balance. And if my understanding is correct, I haven't given this much thought, Chief Justice. It's just came to
Sure, I understand, yeah.
my understanding is that we're really caught in a situation we're at an intersection where we have to deal with a number of issues such as making our economy more, opening up our economy, and those are where collusive and other practices are bad, and these corrupt practices hold us back. Making sure that we retain things like employment growths. So there's a number of other factors that would have to come in and be balancing, and that's why I say it's over the years, the last 20 years, there has been a fair amount of crystallization that has taken place. But that doesn't mean we must sit on our laurels. There's a lot to do. And I again come back to what you said in the beginning, Chief Justice, and that is that the legislature needs to revisit some of these things.
Yeah.
I have no problems with that. And on a last note, I must say, when the legislature introduces some of those things, it's important that one takes heed of them.
One question that really doesn't go to testing your suitability as a judge, but is necessary. Do you get a sense that wrongdoing in the private sector enjoys nearly as much publicity as wrongdoing in the public sector? Or is it just a flipping, reporting about what happened, and then it dies off as if nothing has happened?
I certainly believe that multifarious practices in the public sector gets far more coverage. I think that goes without saying. I think one can, what do we judges say, take judicial notice of that fact. I think it's clear. I mean, one just needs to open the newspapers and one sees a lot of it. But I also have to say this at this point, and that is that it does seem as if it's a lot more people seem to be affected by it. So you see people complaining about the traffic official demanding cool drink money or something like that, you know. And so it does become, it appears a lot more pervasive than in the public sector. It appears so, but I would agree with you that the public sector one receives a lot more coverage, and there's no doubt about that.
I must say, I get shocked every time I go abroad to realize how cheap things are compared to South Africa. Things like dry cleaning.
Yes.
And I say that's where the competition law ought to come in.
I would agree
to
with
make
you.
sure that there is sufficient competition to scale down these skyrocketing prices for almost anything.
Yes. We pay so much, for example, for data.
And that's how it hits the public.
Yes, yes.
Probably more than, what do you call it? This cool drink money.
Yes. No, absolutely.
Yeah.
Absolutely, Chief Justice. And bank charges is another one. Thank you. I'd agree with that. I mean, bank charges are incredibly high. There are lots of those sorts of charges that our country has absorbed, which without questioning.
Yes.
But
And that goes to the heart
of
the critical role that the Competition Commission, the Tribunal, and the Competition Appeal Court is designed or intended to play in easing things up for the South African public, isn't it?
Yes, I think there's a role it can play.
No. Is it not the role it is supposed to play?
It's one of the roles it should play.
Oh, I see.
It's one of them. There's a lot of roles, and I do agree with you, Chief Justice. it should not be a role that receives less attention than any of the other roles it plays.
yes.
But it's practices that are quite difficult to prove, and unfortunately that's what we need to do something about, how we can bring those to the attention of the commission, the tribunal,
And capacity building issues
and the
for
co- and-
those who
and the-
investigate.
and the appeal court.
Yes. Thank you very much. Judge President Davis,
No, before Judge.
is it a follow-up?
No, no, the judge wanted to address something and then you were still talking. He wanted to talk about data.
About
Data,
data?
yes, yes.
I said,
Yes.
yes, I've
Oh, I'm
forgotten.
sorry, I didn't pick that one up. Thank you, Commissioner Malema. What is it about
Commissioner
data?
Malema, I now even lost my thoughts.
I beg your pardon?
I said that was one example. I think we pay so much for data in this country compared to what you get for data in other countries. I mean, it's amazing how cheap and how available it is in other countries. I mean, you find it in the streets. You can open your phone and you can get data, and it's no problems, you know. I mean, what we pay is unbelievably high. Our telecommunication system, they need to look into some of those things, yeah. But then again, we have we have institutions like ICASA, if I remember correctly, that are supposed to attend to those kinds of things. Sometimes, Chief Justice, one gets the impression that it's not so much finding institutions and finding people. Sometimes it's a case of us just not doing what is already there and taking advantage of it.
Yeah.
That's the impression one gets. But talking as a judge, I can only make a decision when something's brought before me and with evidence that is acceptable.
But also, as you reflect on your judgments,
Yes, Chief Justice.
and something that you don't have to decide but is of importance that comes up, isn't it your responsibility to highlight it without deciding it?
Absolutely true. And I
To
try and-
conscientize the legislature about that responsibility
In-
without
indeed.
dictating to it.
Indeed, and I try and do that not only in the competition appeal court. In fact,
Yes.
in all my judgments, I will raise those issues without fear or favor, and I will make adverse comments about people, even if they made obiter. I will do so without fear or favor, and without, as I say, without and leaving it thereafter to the rest to deal with.
Yes. Thank you very much. Judge President Davis?
Yeah, perhaps let's start with this question. You're quite right. I mean, it is a complex issue. I know you think it's simple. You said it was simple. I'm not sure it is. But
What is simple?
you said competition law is not that difficult.
Well, I said I didn't say that. I said I did more complicated matters in the High Court,
Okay, fair enough.
and I challenge you to deny that.
Well, it depends.
That I
You
challenge
may-
you. I've
that-
said in
I
the few
can't-
matters that you've put me in,
I can't deny.
and you cannot deny that the cases I've done in the
I
High
don't want to have an
Court.
argument with you. What I want to ask you, I have a different view, but that's your view, and that's fine. What I wanted to ask you was that, I want to just comment on this. Do you think, when you look at the competition jurisprudence, particularly of the Competition Appeal Court, with the judgments that have actually looked at 4.1b, not the penalties, don't you think that we've broadened the ability to find an agreement, make it easier for the Commission to actually ground the cause of action on an agreement to concerted practice?
I
I'm
think-
referring to a string of judgments in the last 3 or 4 years.
Look-
Just interested in your view.
I mean, I'm not sure everyone in the Commission will agree with you,
Yes, but I'm
But-
asking your view.
and I think it's a point that's arguable on both sides. I think some of them have felt that the appeal court may not have brought clarity.
But
And I can't say it's...
so you don't think from the judgments that there's a broadening, which is what most of the
Oh,
commentators
there
say?
certainly is. Oh, there certainly is. The fact that we talked about how you should look into how certain phrases should be interpreted.
No,
it
no,
openly
I
says...
meant the question of proving of agreements, which are vital to the proposition being advanced about trying to... You can't penalize people until you find that they're part of 4.1b. That's
Yes.
what I'm asking you.
Yes, there is. But if you look at, Justice Davis, if you look at the amendments, if what you're saying is correct, then there would be no need for the amendments, or the proposed amendments.
Is there an amendment to 4.1b?
No, there's a, I'm not sure if there's.
Well, there isn't, so I'm just going to, that's why I'm
Can't,
curious.
now you've, there
Can
are
I
some
ask you about
proposed
the-
amendments about what is the required standards of proof.
No,
and-
that's for pricing.
That's
But
for
can I get to ask you about the amendments? I'm interested in your view because, as you rightly say, we're going to move now to a very important set of amendments because my understanding is the amendments will move from conduct to structure. And for the first time in our 20 years, we'll now be able to attack the structure of companies, for example, such as the data, even if they're not doing anything conduct-wise, to actually open up the structure. I'm just curious about your view about those amendments and whether you think they're appropriate.
Again, I'm going to be very careful about what I say because there may certain matters that question
No, I appreciate
the
that.
amendments
The
and
amendments
that
haven't got to law yet.
produce, and that may raise a debate about what the amendment stands for or intended to. What I would like to say is the amendments recognize that there's a lacuna, and that's important, and that the amendments are now making an attempt to try and overcome that lacuna.
And the
And I
lacuna,
think-
lacuna being?
Well, it says there quite clearly that there's even after 30 years, the concentration in of our economy is at an unacceptable level. It says after 30 years, the racial ownerships of our country and the racial participation of our country is unacceptable. And that's what the amendments are trying to do, over and above these questions of collusive practices in it. It says that some of these practices has resulted in growth of unemployment. Now, these are important questions that the amendments are attempting to attend to, and they certainly are problems that our society faces,
Could I
and
ask-
we cannot turn a blind eye to them.
Could I ask you, one of the controversial amendments is the abolition of the yellow card. What is your view about that?
Yeah, I actually.
Chief Justice, sorry, you can't hear the
Sorry?
Judge President. It's difficult to hear the Judge President.
Oh, sorry.
Yes, thank you.
Amendment
One
of
of the
the yellow
most
card.
important amendments is the proposal to get rid of the yellow card.
No, again, Justice Davis, someone may come tomorrow to my court and challenge that. I sit in a different court as well.
No, but I'm asking-
and may want to argue to me that that's unconstitutional.
Well, let's leave the
So I want to
unconstitutionality-
say, I want to be careful of saying, look, these are matters that could possibly come before me.
Well, how do you
but I
view-
can see the intentions, and I would expect them to show me to what extent it affects them.
Could I
What-
ask you though, just what you think the effect of the yellow card would be? I'm not
I
asking
think
this
it would be I think getting rid of it might have a positive effect.
So where do you think it applies then?
If my memory serves me correctly, the yellow card applies in the case where someone's committed something that is wrong, and they were then told that you're now being given some sort of warning, and then the proof. You may not have known clearly that this was wrong. I see you nodding approvingly. I'm not sure.
Well, no, I'm not examining you. I'm just asking because
I'm wondering.
It's a very important issue.
If this is a test.
Could I?
Yeah,
all right. Can I ask you then, if we could move on? Could I ask you as well? You're right. The Chief Justice has articulated correctly this issue of corruption, and of course there are forms of cartel behaviour. The bread cartel being one, which is unquestionably, it never got to us, which is about corruption. What I'm intrigued about is, what is your attitude to the criminal law, which, by the way, is in the Act, but somehow hasn't been implemented? Do you think, what I'm interested in is, do you think that's a more appropriate mechanism, that directors who ultimately are responsible for these kinds of activities, such as high prices of bread where poor people it's just extraordinary that this should happen in South Africa, that people shouldn't go to jail for that.
No, I mean, I have no problems with people breaking the law going to jail. I think that's what we should do, or pay fines. I don't have a problem with that. I accept that. For me, as I said in the last interview, there is a difficulty with regard to proving them. And making sure that there is the necessary mens rea, etc. But I want to take you up on something, and I really think it's necessary to do this. It's one thing to say that we we must take action against cartel behavior. It's another when you sit in a judgment, as you and I have just done. And when a party says, I'm not willing to give you that evidence because it's not relevant, and then you take a narrow view of relevance, then I think you're not acting in
No,
the
I don't
interest
think
of
that's-
justice.
I
I don't want to
think
get
that's-
into what the
that's-
judge
Colleagues,
was
just
about.
give each other a chance. Yeah, I think it's interesting when you're sitting
My
together.
last question is this.
No, has he finished? That's my problem.
he
It's, I think he hasn't
Yeah,
finished.
but I don't think it's
Actually
appropriate
lose my
to debate a
thoughts when I
judgment
have
that
to
might
get
go on
into that
appeal,
level,
Chief
but-
Justice.
I beg your pardon. Had you
it's-
finished?
I think so, Chief Justice.
Oh,
I
wonderful.
think so.
Judge President Davis, please go ahead.
Yeah. Well, I suppose then, just this particular exchange reveals something. What is your attitude towards collegial courts?
I think there must be, but I do believe, and this is very important, there must be also independence.
So could I ask you?
And I think
accept
there must be collegiality, there must be debate, there must be discussion. I think you must be open to persuasion in a collegial court. I think you must listen carefully to what other people say.
I think that's right, and I think that.
But at the end of the day, you
admire-
must never be afraid
No, no,
to
I
take a decision and articulate it. You must articulate your position so that not only your colleagues, but the rest of the world can see it.
Yes, I think that's right, and I think I admire
that's-
people who, stick up for their positions, and minority judgments are important. What I suppose I'm asking you is, I find it curious that for 18 years, and by the way, Mr. Mpofu, I've only written 35% of the judgments, not 60. But I'm
Sorry,
curious
not
that we've
sure
had.
what- I don't know what you're
that's not the
speaking
point. That's not-
about.
No,
but-
please,
but
colleagues.
the point
I
I
think
was- so the
no,
point- sorry.
JP, let me just sort out something. I think I'm going to have to guide the way you interact. Judge Valley, let the JP put a question to you. When
I do
he is
apologize,
done,
Chief
I'm
Justice.
just-
then you'll respond.
That's it's my
JP?
last question to you, and it's just simply this. It's very important. Over the years, of course, I haven't sat in all the cases, and we're trying to get to a position now where we can have two courts sitting. So that's much easier. But I am curious because since you've been on, it's the only times that we've ever had minority judgments.
Since I've come in.
Yes. We've never done that before, and we've had all sorts of distinguished judges. So I'm just curious about your role, your concept of collegiality.
Well, look, fortunately, of you suggesting, and I'd like you to be upfront, Justice Davis, that I'm not collegial, then you'll have to give me examples. The fact that my judgments come out differently, they're there for the public to see, they're there for the commission to see, they're there for the tribunal to see. We have differed on points. I've argued my points. I don't know whether you've had enough conferences. That's because you're the presiding judge. You know what you're doing. You know how you're running your court. That's for you to decide. I have put forward my positions. My arguments are there. My judgments are there for the rest of the world to see. One or two have gone to have understand are going to the Constitutional Court. The Constitutional Court will then deal with them thereafter. If there was another court, that court will look after it. But what you must understand, collegiality cannot translate into concurrence with other people. It cannot. And you must, and Justice Davis, it's better if you sometimes distract me with your facial,
I'm so sorry.
with your facial. Justice Davis.
I'm so sorry. I accept that readily. May I say I accept that readily? What you
Justice Davis, what you need to tell me, if you feel, is it whether my arguments, my participation, my preparation for those cases, my understanding, my interaction with counsel, and finally, my drafting of the judgments, whether that shows that there is any problem there.
No, I accept that.
That is what counts at the end of the day. We are all independent judges.
I
We
accept
must
that.
respect that,
I accept that.
Justice Davis. If we want to all be like, what's it, the tin soldiers. Remember that play about tin soldiers, what made everybody into Nazi troops? I can't remember that. Then we will never get anywhere. If we must celebrate diversity of ideas. And as judicial officers, we must actually do so with pride. And we must recognize that there will be differences of opinion. That is why you have two parties arguing before you. taking differences of position. I mean,
I accept that really, Judge Valley. It's
Thank
just that
you.
I wouldn't have thought that many of the judges who are on the Constitutional Court and the Supreme Court of Appeal have passed through our court were tin soldiers.
no, I don't know. Chief Justice Davis, it's important that I don't get misunderstood. All I said is we do not want a society where we do not celebrate a diversity of ideas, where we do not appreciate and understand and take advantage of differences in thought. And in judicial officers, we know that we can never always be right. We will have to put forward our points of views. We will debate them. And to the extent that we may be wrong, there's another court that will look at it later on with a keener eye and a fresher eye. But we must just allow everyone to express their views.
Colleagues, I assume that this which I've just witnessed does not by any stretch of the imagination suggest that if appointed, you would not be able to work together.
Oh, on the contrary, I think we have a good relationship, despite of what everyone else thinks. I do hope that we have not given, and I believe I will speak here on behalf of Judge Davis too. I hope we haven't given the impression that we do have a turbulent relationship. On the contrary.
Chief Justice, I just wanted to call that these are questions which my colleagues also asked me to pose. I felt they were necessary to pose, and I perfectly accept that Judge Vally and I generally go back a very long way, as he will, from the time that he was at Warwick. So I assure you, I think your inference that you might draw is not correct.
That makes me feel
Justice
better.
Davis, there's something you said there that I can't let go. Your colleagues asked you to ask these questions to me. That raises a question for me. Who and why and what? And I'm entitled to know that. But I would take that up at a different forum maybe.
Sure.
But I think if that was designed to jeopardize my position or to do that, then there's a problem. Then there's a serious problem. I mean, then I'm not afraid to face facts. I've never run away from these things all my life. If I see something that I think that's wrong, I'll raise it.
Thank you, Judge Valley.
Chief Justice?
Is there a follow-up?
I just want to come in there, that with my little experience in this forum is that the heads of the courts, when they are coming to this forum, ordinarily they consult with their colleagues
Okay.
as they come here to consult broadly. These are the candidates, what are the views, and from time to time they will even say, your colleagues think that you are an appointable candidate. What do you think about that? Your colleagues this. So I don't think there is anything new and anything untoward. And I thought I must just come in quickly there to say, unless there's something else. But if it's in the spirit of what we've been experiencing throughout, there's nothing new that Judge Davis said.
I've been in my experience
It's
over
enough
20
to
years on the
say,
JSC.
it's enough to say some colleagues prefer to do it. I don't canvass views of colleagues on any candidate. I think I appreciate that some may prefer you, others may not, but come here and demonstrate your suitability for appointment. Let's look at your track record, and on the basis of that, and not because others favor you, others do not favor you, because there may be other complexities related to what others think and whether it should be of any
Manifestly, I
significance.
agree with that, Chief Justice.
Yes.
Obviously.
Yes. Thank you, JP. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Judge Vally.
Good afternoon. I
Thank you.
can't see who's speaking.
Oh, sorry, can you
Good
see now?
afternoon. Thank
Oh,
you.
Thank you.
Commissioner Norman, can I advise on something? I see it happens to Commissioner Nkosi Thomas. The mic is this side, but because when we speak to people, we face them.
Yes.
You then speak away from
so
the
let's
mic.
just turn
The
it this
result is the machine doesn't quite capture what you say all the time.
Thank you.
So it's best if it is in the direction of your mouth.
Yes,
Yes.
thank you, Chief Justice. Thank you. Judge Vally, everyone, in fact, even Judge Mnguni, including the Judge President of the Competition Court, they seem to feel that once there are amendments, then the Act itself will have some teeth.
Some
Some teeth. Some,
teeth.
yes.
Yes, thank
But what I don't understand is this, the current Act as it stands, it makes, and it has in its preamble, one of the purposes to regulate the transfer of economic ownership in keeping with the public interest. So that on its own should enable then the tribunal to be able to meet that purpose and give judgments that will make sure that there is that regulation and that transfer of ownership. What is keeping that process from happening? Because now we know we have an act that can actually be used to achieve that.
Thank you. The answer, I think, lies in the memorandum that came out with the proposed amendments. The memorandum explains that even though we're not amending the fundamental principles underlying the Act, there have been certain problems with the way the Act could actually be implemented. And as a result thereof, there was a need to to amend certain sections, like, for example, get rid of this yellow card thing. Like, for example, give more institutional power to the tribunal and the commission. So yes, we haven't changed the fundamental basis, the foundation of the Act itself. But to say that it's in itself enough would not be entirely correct and would probably explain, the fact that it's not enough explains why we still have not been making significant inroads into achieving the very objective the Act set out to do.
Yes, thank you. And then one last question. How does one balance? One finds that a particular company has conducted or engaged in predatory pricing system. And then having found that, then how does one balance, having made that finding, then you still have to ensure that there's still healthy competition. How do you make that or reach that balance?
I'm not sure I understand, but once we found a company has already breached sections of the Act, am I understanding that correctly? Then how does one balance?
Without, you don't kill, you'll make the
Don't
finding.
kill the goose.
Yes, then you still have to promote competition.
Yeah,
So how do you
that's-
balance?
Yes, that's one of the issues that does come up, and it's a case-specific issue, will have to be dealt with on a case-specific basis. But it's one of the issues that comes up when you find them guilty of collusive practices, and you have to now impose a penalty. And you have to decide whether that penalty is going to be, A, deterrent enough of other people, but B, not harsh enough to ensure that that company disappears, because that results in unemployment, that results in lesser competition. And it's a fact that will only have to be dealt with, it's an issue that can only be dealt with on a case-specific basis. And it's in that sense, as I would have said in one of my judgments, it's just no different from criminal law. You'll never get two persons charged for the same offense, found guilty of the same offense, always getting the same penalty.
Thank you.
Always getting the same
Thank you,
punishment.
Chief Justice.
Thank you, Commissioner Norman. Commissioner Msomi?
Thanks, CJ. Good afternoon, Judge.
Good afternoon.
On a lighter note, there's a program that I've watched on TV before called Judge for Yourself. I think I saw it in action and live today.
Judge yourself.
Yes, it's called Judge for Yourself. Oh, it's no longer there. Judge Vally,
Well, the judge is pointing at me because I stopped him from doing it.
Oh,
Yes. Continue, Commissioner.
yeah, Judge Vally, I wanted to ask, I mean, there's a new narrative in our country at the moment, and it has been loosely titled The New Dawn and the Tumamina narrative. And that narrative seeks to say the country is open for business, and therefore international investors must come to the country. how do you think our Competition Act fare in terms
How
of
do I think?
our competition law framework fares internationally? Do we follow best international practices when it comes to our competition law? And if you think we don't, how do we not? And if you think we do, how do we comply with international practices?
Okay, there's about 3 questions there. Let me try. I think we fare fairly well. I think we are respected around the world. Not only, I mean, for the way we've dealt with these matters over the past 20 years. I think that I've discovered by having met people who are involved in competition law in those countries, telling me what they thought about us. Insofar as how do we fare with regard to assisting or inviting or encouraging people to come and invest in our country, competition law is just one element that we deal with in that field. But we have to recognize that it's a double-edged sword. They want to come in and they complain that at one level we have to close the market and we need to open up that market. At another level, they may not like the fact that some of the things we do, just like in our labor law, may not be things that they'd like. And there they have to understand. We have our own social problems. We have our own issues to deal with. And we will come with something that is bespoke, that is unique to us. And while we have every wish to bring them along here, they will have to work with us to assist us in overcoming some of these problems. And I think that if we make that point quite clearly, and I think our people are doing it very competently, as you say in the new narrative, and I wish, and I hope, and I believe we will make significant strides. But we're not unique. I mean, the world is the world's going through some difficult times, you know. And everyone goes out there trying to do it. And some people think it's not competition law that solves the problem, it's taxation law. And some people say, I must drop my tax to 15%. So there's so many other issues. But we must never assume that one area of law is going to solve all our problems. It is not a panacea. It will never be the panacea.
Thanks,
we
Judge
must
Vally.
take
I think you have answered the question quite extensively. The second question that I wanted to ask is, I have seen, and you must correct me if I'm wrong, situations where there has been a Hollywood type of raids when the Competition Commission is conducting raids.
I can't hear you correctly. I'm so sorry.
Okay. What I wanted to say is we have seen Hollywood type of raids being conducted by the Competition Commission on companies, where the SABC crew is invited to witness this raid. And I wanted to ask you, how should we balance enforcement? How should we balance enforcement and the protection of the right to privacy within our competition law framework?
But the competition law has got a number of protections already stated. Things are confidential, they can't be made available to everybody else. They only to be seen by the commission, the tribunal, and eventually only the Competition Appeal Court. But I
sorry,
actually
Judge Vally.
didn't understand the first part.
Sorry.
How do I the SABC doing what? Raids? What?
No. What I'm saying is you find situations where there is a raid.
Raid?
A raid.
Oh,
You know, when the
R-A-I-D,
Competition
sorry.
Commission sets on your company
Oh,
and
right.
they go and they raid your company to look for information.
Oh, correct.
What I'm saying is, well and good, there must be law enforcement, which must be conducted within the prescripts of the law. But what I find disturbing is a Hollywood...
Publicizing, the publicity surrounding
How do you
it.
balance the right to enforce the law, Judge Vally,
Oh, I
against
understand.
the right
I
to
fully
privacy?
understand. I do apologize. I didn't. No, I do think that there is a problem when there's an overzealous publicity of an issue of an alleged alleged breach, and I do believe that there should be a great deal more sensitivity in the way these things are done. They're not. I mean, in a sense, they're not very much more different than you get from POCA raids. Sorry, I don't know if everyone knows. POCA is Prevention of Organized Crime Act raids. And sometimes they do it in an overzealous way. Not so much with publicity, but they also sometimes cause a great deal of damage. They would come in and break doors and things like that, yeah. And I think those are problematic. But those are not issues that the law can solve. Those are issues about practice by people out there, you know. And
by
the
the way-
tribunal and the commission, of course, and fortunately the appeal court doesn't get involved in that. The tribunal and the commission, I would hope, are more sensitive to protecting the privacy and the rights. Sometimes publicity also works against the regulators. You know, they should try and avoid more publicity. Is not always good for them. It's sometimes bad for them. But that's a decision they'll take at the time. I just hope that they would protect and respect everyone's rights.
By the
And
way,
there I would be with
okay.
you.
Thanks, Judge Vally. There is, by the way, a decision by the SCA on the famous decision of the PPC. It was the cement on that issue. The last question, Dr.
That's the third one, my brother, but go ahead.
Yes, the last question really is the draft guidelines that have been published by the Competition Commission on information exchange between competitors.
Yes.
Do you think that guideline helps the competitors? I mean, I read it because I have an interest in this area of law, though it's mystified, as Advocate Mpofu was saying. But I found it that when I read it and compared it to its European counterpart, I found it that ours lacked in detail. Almost everything mentioned has what I would call a chilling effect as to what it is that you can exchange and what not without offending the Act.
Yeah, I would certainly sympathize with your view. I think that it's certainly a concern, and it may have to be looked at more carefully. I would have no difficulty with that. But I mean, this is what it's all about. It's publish it. Let's hear from everybody else, and then we'll clean it out as we go along. And I'm hoping more people will come out with comments like you've just come out with. So an alert the persons drafting to the potential problems. Thank you.
Commissioner Nyambi?
I'm fine, CJ.
Thank you. Commissioner Singh?
Yeah, thank you, Chief Justice. Just a quick one. Commissioner Msomi mentioned one narrative, which is the new dawn. But there's another narrative that's doing its rounds in South Africa, and that's radical economic transformation. Now, when I look at that narrative, I'd just like to know, in my view, there's more collusion than competition in the business world. If you look at stores which sell clothing, you'll find 10 stores with different names but owned by the same holding company. You find a company that rents out cars at the airport. I think we all know that company. I won't mention them. But they do catering. They do every kind of thing that you can think of under the one brand. Are we doing enough in South Africa to promote radical economic transformation and stop this kind of ganging up by holding companies to own many little subsidiaries?
If you can be as brief as circumstances permit you.
So I missed that, Chief Justice. I was thinking.
I was saying, so far as you can, be as brief as possible.
Thank you. I mean, if we were doing enough, we wouldn't have the problem. We got a lot more to do, and there's a lot of different areas we can work in. I don't see a difference between the two narratives. I think they're reconcilable. I don't think they're mutually exclusive. But I agree with you that there's a lot of collusive and other practices. It goes not only undetected, they go undetected and unpunished. And that's the same point the Chief Justice made in the beginning, which I concurred with.
I think the question, Chief, are we doing enough, you think, as a country to stop this kind of collusive behavior? Thanks.
As a country, I think there's a bit more we could do. There's a lot more we could do, maybe.
Thank you. Your excuse, Judge Vally.
Thank you, Chief Justice.
Oh, I'm sorry. Oh, you had not raised hands, so I thought this time you'll pass. Okay, Commissioner Kane?
There were a number of questions that I posed to the previous interviewee that I'd like just to get your response on to gauge the manner in which you would embrace your tasks if you were to be appointed to the competition court. The first question is a question which emanates about cost standards under Section 8 of the Act and the practice of predatory pricing. I'm sure you're familiar with that. Could you give the Commission some indication of the way that you would approach a case dealing with predatory pricing, and in particular address the issue of whether intention would be one of the factors you considered relevant to the inquiry?
To the start, I'm very careful always not to say beforehand what I think I'm going to do in a particular case, because I don't know what the submissions would be. But I would start by looking at the consequence of it. Now, there's this debate about variable costs, or whether it's going to be, was it average variable costs or something, and fixed costs. And
Correct. So we're dealing with those concepts.
yes, I have no difficulty understanding those concepts, but I have to look at each of the cases as they come along. And I will only, in the end, consider not, and I don't believe there's going to be an answer definitive for every single case, but I'll look at the consequence, the intention and the consequence of the pricing. And if the pricing is designed purely to end competition so that you can take a loss for a short period of time in the hope that your competitor disappears and then thereafter raise your prices, and that's quite clear and manifest in what you're doing, then I'd look at those costings on the basis of what you really think you want to do, not just on how you. I've always find on this question, Commissioner Kane, that what's interesting is when you go and sit there, you get all these experts who come and tell you, no, but you must look at it this way, no, but you must look at it that way. And it's amazing how many experts you get there that come and tell you those things. For me, the important thing is, what's the ultimate objective? What's the results that you have achieved by doing those? What were those practices? But accounting is such a thing that you can play around with it. Eh? It's like statistics.
Thank you. Let me take you then straight to the next question, which is the role of experts in the court, because you've just alluded to it. And the recent criticisms by the Competition Appeal Court pertaining to experts giving evidence on what are essentially legal issues, and the difficulty in that court of distinguishing law from economics. Can you give us some insight into how you would approach those difficulties?
Excuse me, can I give you some?
Some insight or your views on those issues. And
I've actually written what I would like to believe is a comprehensive judgment on expert evidence. I've put it in the pack. I hope I don't know if you've seen it. I've complained about experts in a number of these. It's not the first time. And the Competition Appeal Court's not the first court to complain about experts. It's been a problem all over. What is quite clear is that as a court, you need to alert experts as to the limits of their role. And it's not just them interfering with law, but it's often them taking over your role as a judge, and them interfering and telling you how you should and what should be there. I mean, they decide, they want to decide the case for you. And yes, experts do not know what their boundaries are. And I've discovered that not only in competition, but in so many areas of law, we've got experts coming in. I mean, my court, it has something like 100 experts that come every day. I'm not joking, every single day. We have orthopedics and brain surgeons and whatnot that are there every day. And I'm hoping that the judgment I've written will give some sort of guidance to them.
thank you for that answer. And my last question just pertains to this difficulty that one may come across when a vertical agreement also has a horizontal dimension. And the fact that Section 4 prohibits agreements in the horizontal dimension. Do you have any views on how you might deal with that issue? You could call it a characterization issue. What would you say about that?
You know, Commissioner Kane, I always try and make sure that in law while we apply theoretical concepts and while we remain as theoretical as possible, we must avoid being over theoretical and must look at the facts of the case. And for me, it's less an issue of whether we're able to put it in this pigeonhole or that pigeonhole. What's important is whether we have it's how it impacts on the objects of the act and the intentions that we're trying to do. And look at what the parties are doing. And I always approach my cases on that basis.
Thank you very much.
Thank you, Advocate KNSC. Advocate Mpofu.
Thank you. Thank you, CJ. Good afternoon, Judge. Good afternoon, Judge.
Good afternoon, Commissioner Mpofu.
Thank you. I just want to ask one of the issues about this area of law, broadly speaking, is that it is almost inherently loaded against the public, members of the public, or it favors the big companies, and that's got nothing to do really with the judges or their inclinations, if I may say so. It's obviously a result of the fact that these big companies have bigger pockets, bigger advocates, and so on.
Yes.
Now, for somebody like you who has a trade union background, what would you bring? What fresh approach would you bring to make sure that there is a balance? Obviously, not necessarily favoring the poor where they don't have to be favored, but making sure that there's the necessary balance.
Thanks. Thank you, Commissioner Mpofu. Commissioner Mpofu, I have a particular a slant, ideological slant. I will never hide it. You know, I come from a particular background. I must say this, I am very, very disturbed and distressed by the levels of inequality in our society. It's not something I've been distressed about now. It's something that's always been with me, and I will bring that slant. And I will always look at their practices in the light of those. I will always be concerned about its impact on overcoming our poverty, on overcoming the inequalities, and of trying to impose greater costs on our people. So that's why I would agree when the Chief Justice says that, look, these corrupt practices, they hurt the poor. These collusive practices only increase our costs. And I will look at what those, and yes, they have deep pockets. And you know what's unfortunate about that, Commissioner Mpofu? They can allow a case to go on and on and on, and it's unfortunate. You know, one of the unfortunate things, and I'm sorry I'm going to be a bit long on this, is that I'm not entirely comfortable with the fact that they would come and say, I want to appeal the small point. We can't even get to the case yet. It's 4 years later, and we're arguing whether this is an interlocutory decision taken by a tribunal or not. And we're not getting anywhere with those cases. They've got deep pockets. They pay phenomenal prices to the advocates that appear before them. They pay phenomenal amounts to experts to do those sorts of things. And we're just not going to be able to stop them with their practices. But it is disturbing. I will fully agree with you. And I find that sometimes, I don't know, I'm wanting to impose costs orders against them. I'm not even sure that there's any deterrent effect, you know. It's, you know, you can tell a rich person, I order you to pay costs. What is that meant to him? So
Thank
you
you.
pay costs, so what?
Thank you very much. The second area is what I would consider as almost a structural defect. I don't know what the solution is to this myself, but maybe you can help us. The examples were made about the fines and the inadequacies of some of the fines. Now, here's the thing, and I'll use an example. One of the probably highest fines or penalties which was paid was in the stadium cases. I think it's the second highest. And unfortunately, it was not imposed by the court, but it was a settlement of some sort. But be that as it may, what you had in that case is roughly collusion amounting to 50 billion rand, okay, in the World Cup stadiums. And then the fine is 1.3 billion rand. Now, if I was the head of that cartel, I would say, let's do it again, because crime pays. If I'm going to get 50 billion and I'm only going to pay 1 billion, then I'll do it every day. You know, as I say, that seems to be a structural problem because of this percentage cap.
The 10%
Yeah.
of the turnover rates.
Can we be able to resolve that kind of thing? I know the judges can't resolve it, but I'm
Yes,
talking broadly.
Commissioner. Commissioner Mpofu, it's exactly the same point made by the Chief Justice at the commencement of this interview. For some of these people, the punishments are just so light,
Meaningless.
relative to their strength, that it means nothing to them. And it's unfortunate, and there's little we can do. I remember, I practiced a lot in labor law, if you may remember that. And I was quite. And one of the things the companies would say is, what does it cost to dismiss him? I don't care about, I'm not interested whether it's fair or unfair. It's going to be unfair.
Yeah.
Just tell me what my price is. And it's done, Yeah. And that person, and dismissal is capital punishment. And the same applies here. And it's sometimes so difficult, but we have to be very careful. We are judges. We must carry out the law. We can't solve society's problems, all of society's problems from the court. It really is. If we think we're going to do that, then I think we are on dangerous terrain.
I think
we'll
what
find
the-
ourselves stepped.
I'm sorry, Judge. I think what the Commissioner is asking you is, with the benefit of your reflection on these challenges
Yes.
and your experience, if you were to be asked to address the powers that be in relation to the solutions, what would you say? I don't think he's inviting you whenever you have a case to go out of your way adventurously.
I'm sorry, I
and,
always
and
am
pretend that
conscious.
you're dealing with the issues when in fact those issues are not before you.
Thank you. I'm sorry, I always am conscious of the fact of when I'm sitting as a judicial officer and the limits of a judicial office. Yeah, I think there are a number of possible changes our country could possibly could be able to look into. But this is largely policy-based issues that the country has to do. And I think it's best left to people that have got the right kind of advice and assistance in that. My view would be, maybe we should impose harsher punishments. Maybe you should say to them that if you're caught on something which has such a significant impact on the public purse and on the public as a whole, expect a very severe punishment from us. And if the legislature says to me then that that's what I must do, then that's what I will do. I will say to them, I will. But that's for the legislature. They must look at it carefully, and they have better ways of dealing with these things than we have. I will just tell them, look again into it, just like they looked into minimum sentences. You look into it. We're not achieving what we set out to do.
Thank you very much. The last one is maybe a double-barrel question on judgments. Firstly, there is a statistic which the JP was contesting just now about the number of judgments in the CAC that are written by one person, let's put it like that, to be diplomatic. And the figures, and I must say that this figure was, the reason why I was bold to put it, JP, is because it was articulated by one of your judges, Judge Rogers, in public. So put aside whether the figure is true or not, but if it is true that more than 60% of the judgments are written by one person, is that desirable for a court of this importance and stature? And while you're answering that question, I've noticed you have a penchant, if I may put it like that, of writing dissenting judgments. Firstly, did you find that it was necessary for you to dissent so frequently? And what was the attitude when you do so?
Let's start with the first question. Judgments penned by one person. I don't know the statistic. I'm enlightened by you as to the statistic. I think it is problematic. I think one person's view should never set out the entire jurisprudence of an area of law. I've now spoken earlier about ideas must be as diverse as possible. I don't know why that had been so I can't comment on that. On the second point, I've answered that question, Justice Mpofu. Justice.
Thank you for the
Mpofu.
elevation.
Commissioner Mpofu. Sorry, Commissioner Mpofu. I hope you didn't see that as an insult.
No,
Commissioner Mpofu,
I can live with it.
it's important to bear this in mind, that we sit there as 3 judges or as 5 judges so that parties may be able to feel comfortable that not just one person's going to be making the decision. And that then the 3 of you or 5 of you have to sit down and debate them. Now, it's not as if this court is the only court where I sit in where there's a 3 bench. I sit in many 3 benches in the Gauteng High Court. I actually preside over 3 benches now. And quite significant cases. So it's important that we sit down and discuss and look at different angles. Do I have a penchant? I think that's unfair. I don't deliberately go out to dissent. But my judgment speaks for itself. And I say to you in that judgment where and why I disagree. It is a duty of mine to tell that to my colleagues, to tell that to the litigants, and to tell that to the public. And I believe otherwise I'm not going to be serving my office properly if I'm just going to. I'll try my best, I listen to my colleagues, I try and cater for what they have to say. I take them very, very seriously what their views are. But at the end of the day, if it's irreconcilable with mine, then I have a duty. And I believe that I should carry out that duty. And the day I stop doing that, then I don't think it's worth being. Then I think I've failed South Africa. And it's not because I come from a different ideological slant. It's not always ideological. It's different perceptions, a different way of looking at things. I mean, it's...
Yes, Commissioner Mpofu.
Thank you very much, CJ. Thank you, Judge.
Thank you very much. Judge Valley, thank you. You're excused.
Thank you, Chief Justice.